This is part 1 of a video where we will be discussing the steps of the trial process in a criminal law case. This video was prepared with the assistance of PBSC University of Manitoba law student volunteers. PBSC volunteers are not lawyers and they are not authorized to provide legal advice. This video contains general discussion of certain legal and related issues only. If you require legal advice, please consult with a lawyer. In part 1 of the 2 available videos, we will be discussing what an arraignment and plea are and what happens during this process, what an opening statement is and its purpose, how witnesses are called and the steps that are followed, which include swearing in, direct examination, cross-examination, and re-examination. In the second available video, we will be discussing objections, voir dires, closing statements, and sentencing. The first part of a criminal law trial is the arraignment and plea. An arraignment is a proceeding in a criminal law case where the accused will appear before the court and enter a plea to the crime they are charged with. The charge will be read aloud to the accused, and the accused will be asked whether they plead guilty or not guilty. The second step of the trial process is the opening statement. Opening statements are optional, but if there is an opening statement, the Crown will present their opening statement first. The defense may make an opening statement either right after the Crown Attorney's opening statement or right before the evidence for the defense is presented. The purpose of an opening statement is to provide an overview of how the trial will proceed, and it allows the judge and jury to follow the order of the evidence and witnesses that will appear. An opening statement allows each side to provide the following: a detailed account of the offense the accused is charged with, the facts that each side is hoping to demonstrate, and the order the evidence will be presented. The Crown Attorney, who may also be referred to as the prosecutor, presents their opening statement first. The defense, who may also be referred to as the counsel or lawyer for the accused, presents their opening statement after the Crown Attorney or after the Crown Attorney closes their case. After the opening statements from both sides have been presented, witnesses will be called. After the arraignment and plea and opening statements, the trial will begin with witnesses being called. The Crown will call all of their witnesses first. Afterwards, the defense will call their witnesses. Please note, the defense may not have witnesses to call because it is the Crown that must prove a crime has been committed. When witnesses are called, they will go through the following, which we will go through in further detail: swearing in, direct examination, cross-examination, and re-examination. When witnesses are called, the first step is swearing in. The accused and the witnesses are required to provide their evidence under the oath or affirmation. A sacred object of their choosing, or the Bible available in the courtroom, may be used for swearing an oath. Parties may also affirm to tell the truth without the use of a sacred object or the Bible. After a witness is sworn in, the Crown Attorney will begin asking the witness questions. This is called a direct examination. The Crown Attorney's witnesses are called first in the order outlined in the opening statement. Direct examination questions are used to get a witness to tell their story, so the party questioning the witness cannot ask leading questions. Here are examples of what direct examination questions may sound like. Where do you currently work? How long have you been living in Winnipeg? Where were you on February 12th, 2021? How many others were in the store at the time? Were you able to see the robber clearly? How tall was the robber? After the direct examination, the defense has a chance to ask the Crown Attorney's witness questions. This is called a cross-examination. A cross-examination involves leading questions to try to get the witness to change their story. This is done to make a witness look unreliable. Here are examples of what questions from a cross-examination may sound like. The accused was standing quite far from you at the time, correct? So it's possible you didn't see the accused's face properly? The accused was wearing black at the time, right? There were also 3 others in the store wearing black, right? After the cross-examination, the Crown Attorney may choose to do a re-examination. This involves questioning the witness one more time. This is done as a final clarification of the witness's evidence or to address a new issue that has been brought forth from the cross-examination. After the Crown Attorney is done presenting, the defense can provide evidence that supports the accused. The process is the same as the Crown Attorney's witnesses, which involves swearing in, direct examination, cross-examination, and re-examination. This brings us to the end of part 1 of the video about criminal law trials. If you require more information, please visit the following web pages.